Hello and welcome to the next episode of Mayor Brown's video series at the Crossroads, CFTC and DOJ Enforcement. My name is Matt Kluchenek, a partner at Mayor Brown, a member of Mayor Brown's Litigation Dispute Resolution Group. I'm joined today again by my partner, Glen Kopp, a member of Mayor Brown's white collar defense team and a former federal prosecutor out of the Southern District of New York. As you know or may know, each week we seek to bring to you an interesting topic relating to the CFTC and the DOJ regarding commodities enforcement. So this week, we're going to continue on our theme regarding the impact and requirements of cooperation, whether it's self-reporting, whether it's responding to voluntary requests, whether it's remediation, so on and so forth. And so today's focus is going to be on the Department of Justice, cooperation standards, expectations, and requirements. And so with that, let me ask my partner, Glen Kopp. Generally speaking, Glen, what does it mean let's focus on individuals as opposed to entities, for an individual to cooperate with the DOJ in an investigation?
Sure, Matt. So when it comes to individuals, there's sort of formal cooperation and then there's sort of more colloquial cooperation. So we'll set formal cooperation aside for a moment because that's a real process that we'll get into in a minute. But in terms of cooperation, there's a number of different ways someone can cooperate in the context of a DOJ investigation, and in particular in the context of the commodities space. You can provide you could get a subpoena, right, and provide documents. Even before you get a subpoena, you can get contacted perhaps by law enforcement and you can agree to sit down for an interview. You can agree to provide documents. And so there's sort of a number of ways to cooperate. And then there's ultimately some more formal ways that you can cooperate in the context of DOJ investigations. But cooperation generally means giving the government what they, what they ask for.
Thanks, Glen. So for those watching, many may be familiar with the use of cooperators in the context of drug trafficking cases, a whole realm of different types of cases. But does DOJ use the same, we'll call it tactics, with respect to commodities fraud investigations when it comes to cooperators and cooperation?
Essentially, yes, Matt. I think DOJ sort of develops a lot of the skills in looking at criminal enterprises and sort of more of your standard sort of cops and robbers crimes, but they apply a lot of those tactics in the white collar space as well, and commodities fraud is no exception. And so when it comes to building cases, they do oftentimes look for not just witnesses who might give them information about fellow traders, but they'll also look for information concerning potential cooperators. And in that context, in more formal context, what they're doing is trying to find someone who's sort of at the heart of a criminal conspiracy or a criminal scheme and get them to provide information about their co-conspirators, about others who are also committing crimes. And that may be others perhaps on their trading desk. In the context of both, large-scale criminal enterprises, both in the drug context as well as in commodities trading, they'll also look to sort of go up the chain. So oftentimes cooperators, formal cooperators, will be sort of lower level employees who provide information to the DOJ about their superiors so that DOJ can make cases against folks up the chain, as they say. And when I say cooperators, that is actually the formal term. What I'm referring to is someone who ultimately pleads guilty to charges, and in the context of pleading guilty, will enter into a formal cooperation agreement with the government, requiring them to provide information to the government about not only all the things that they did illegally, but also about others so that the government can help build a case against those other individuals. And the purpose for that is that cooperator is hoping at sentencing ultimately to get the support of the Department of Justice and provide what's called a 5K letter, a letter that describes all the bad that the defendant did or the individual did, as well as all the good things they did to help DOJ make cases, in hopes that the judge at sentencing will consider that and provide a lower sentence to that defendant. So that's sort of the formal cooperation process in general. And it's something that, again, is used across all types of criminal conduct and has been used in the context of commodities fraud cases. There have been witnesses notably, you'll see them at trial show up. Most recently, in the Vorley and Chanu cases, one of their colleagues was a cooperator, so who had previously pled guilty prior to testifying at trial.
Yeah, and certainly it has not been uncommon to see cooperators with respect to commodities fraud cases. And so that seems to be clearly a trend. Glenn, so with the CFTC, there are several of these so-called cooperation advisories that have been issued publicly. And that's cooperation in the very broad sense in terms of conveying the CFTC to the marketplace. These are our expectations. Any paper the DOJ has issued along the same lines?
So Matt, yeah, in the corporate context, for sure. DOJ has historically or has over the last number of years tried to convey more transparency about what is required for full cooperation, as well as what are those steps, and what credit you get for that, like literally the percentage credits you get, as well as a presumption of non-prosecution in the context of, first in the FCPA context initially, or the Foreign Corrupt Practices Act, and then more broadly in other kind of criminal enforcement investigations. When it comes to individuals, you've got the DOJ manual that sort of sets out ways in which DOJ approaches different individuals, whether they be witnesses or subjects, and ultimately cooperators. But they've, I think, made it very clear over the years through cases and publicity about what the expectations are when it comes to cooperating. And it sort of varies slightly within districts in terms of how much information a cooperator has to give up about themselves. But generally speaking, you've got to tell them what you've got, all the crimes you've committed, before they're willing, or DOJ is willing, to sign a cooperation agreement with you.
Great. Okay. So very, very helpful. Let's get a little bit more strategic here. Talk a little bit how a would-be cooperator can best position himself or herself for optimal treatment vis-a-vis the DOJ.
Sure. So Matt, I think what you're getting at here is really the need to have early engagement with the Department of Justice through a lawyer in order to get the best treatment. Because what you really want to do is start talking to DOJ before an indictment is brought, in order to maintain maximum flexibility and optionality. And what I mean by that is that cooperation is sort of one of the last things you would want as an individual, right? You want to avoid any kind of charges to begin with. And so prior to indictment, there is still flexibility in terms of what kind of resolution there might be. And so if you engage DOJ at an early stage, you start trying to educate them, if you can, about what might have happened. And so what you're trying to do is keep yourself away from an indictment, and not just an indictment as a pure defendant, but also ultimately as someone who's pleading guilty pursuant to a cooperation agreement. So you're trying to keep yourself in the realm of maybe at worst a witness, at best someone who's not at all able to assist the government in their investigation. And so by working through counsel, by having counsel voluntarily provide information, sometimes through attorney proffers, which protect the information from being used against you. These are ways in which you could sort of continue to stay on the unindicted side of the ledger. There's also a potential option for getting a non-prosecution agreement with the government, which even if you might have been a wrongdoer, or you engage in some misconduct, you potentially could get a non-prosecution agreement in which you're going to provide the government with information. You could ultimately be a witness, but they decide not to prosecute you for your conduct. And that's a consideration that DOJ engages in as to whether or not they're willing to do that with an individual, because as you can imagine, it might not look great to a jury that someone got sort of quote unquote got off and didn't get prosecuted, where others are being prosecuted again, and those others are the ones that the person who received the non-prosecution agreement is testifying against. But if you engage with counsel and you engage DOJ as early as possible, then you give yourself an option, perhaps, of being sort of part of an effort to avoid any indictment, avoid having to plead guilty to a cooperation agreement. And so a lot of that comes from being willing to have your counsel engage with them, answer questions, occasionally provide documents, maybe sit down and do an interview with DOJ. That might be a step of a last resort. If you can have your lawyer do it, there's better protections involved in that. But those are some of the things you want to do to maintain or to get the best result in the context of an investigation.
Great, thanks, Glenn. So with respect to your comment about non-process, so optics clearly matter, right? But important to probably emphasize that a would-be cooperator doesn't necessarily mean it's going to result in a guilty plea. Leverage matters, facts and circumstances, so on and so forth. Maybe there's an admission, but that doesn't necessarily mean that there's a guilty plea. And so there's a lot of things that go into this calculation, right? And I would assume, or as we've seen, a lot of back and forth with the prosecutors on these types of issues.
Absolutely. It definitely takes a lot of negotiating to get a non-pros, especially in the context of a case in which DOJ is trying to build off of. I think they would prefer to have cooperation agreements. I think it's a tighter thing for them. I think it's a stronger statement that DOJ makes at trial if they have cooperation agreements, but they're not always required, and they're not necessarily in the best interest of justice. And DOJ is open to having those conversations if your client is in a situation in which they would qualify under DOJ's guidance.
Okay, super. Thanks, Glenn. How about some takeaways, Glenn?
Takeaways here are that engagement with DOJ as early as possible, as early as you're aware of a potential investigation in which you are at least the subject, is really important. I think, it again, as I said earlier, you maintain optionality. It doesn't mean that by cooperating in the more colloquial sense with DOJ that you're ultimately going to have to plead guilty if you might have been somehow involved with criminal conduct, even in the commodities fraud context, but that you want to make sure that you've got lawyers who are familiar with the process, contact DOJ, have an open line of communication and build that trust, because there are options even if you feel pretty close to the fire.
The best advice. Thanks, Glenn. And thanks to everyone who's watching. We appreciate it once again, and we look forward to seeing you next week. Thanks.